as well as understanding the best ways to strategically approach future legislative sessions. So again, you can take a look at the summary at your leisure, and it is in the chat. The two bills that are most critical to this committee are House Bill 2166 and House Bill 2075. House Bill 2166 was the Criminal Justice Commission Data Collection Bill. This bill was initially introduced in 2020 during the pandemic, but did not make it through the process and ultimately ended up dying. So in 2021, we reintroduced the bill with Representative Blackman as our sponsor. And this bill was a critical step for ACJC to begin building a comprehensive database around criminal justice data statewide. And a lot of you are already familiar with this, but again, we are very happy to announce the signing of the bill. ACJC crafted the survey and has sent it out to all the agencies statewide. And we are currently working on getting as many agencies as possible to participate in the survey. And we're going to continue to actively pursue respondents on that. Next is House Bill 2075. This is the Sentencing, Judgment of Guilt, and Fingerprint Bill. So just a little bit of background. The Attorney General's office was asking for a change along with county attorneys and many courts across the state due to COVID restrictions. The bill removed the when and where requirements for fingerprinting. That way a person wouldn't have to be transported back to the courthouse for sentencing just to comply with the statutory requirement of fingerprinting in open court and at the time of sentencing. So as I understand the law, the defendants will still get fingerprinted or 2FID'd, whichever method that particular county uses, and it just removes the required place and time. I don't know, Mark, do you have any additional thoughts that you would like to add to that particular bill?
Well, in that bill, I think we're going to talk about it later of the in progress part, but in that bill, my concern was that doing the gap report with DPS and the Attorney General's office, the fingerprint on the sentencing doc is what we call our last line of defense in a sense. If someone gets through the system and they haven't been fingerprinted, DPS could use those fingerprints to then recreate criminal history. I've been assured that we shouldn't see an uptick in that, because if you all recall, you all been on this task force way before I came, but at one time we had over 900 people showing up without fingerprints. Last year, the year before last, we had it down to 12 people that showed up without their fingerprints. And this past year, there were 0. So we want to make sure that people don't start slipping through the cracks and showing up without some type of criminal history or fingerprint. And hopefully with the 2FID and things like that, maybe it will mitigate and this won't be a huge impact at all. But it's something that we need to watch.
Yep. Yeah, and Molly, if I can just step in. This is a real example. I think the reason for this was COVID related, but it goes to show that when you don't include all the stakeholders in the formulation of a bill, you can cause some severe problems to some progress that DPS DOC made. So, and
of course, the courts have agreed, Mark, to work with us on if in fact we need to have.
Yeah, we understand that. It's just something, like I said, we need to watch.
Yeah, we'll talk about it a little bit more here. DOC has now a rule that we'll talk about that may make it okay.
Hey, Tony, before we move on, if I could just, so part of the data bill, the first step of what we're trying to do to get at agencies and do a comprehensive look at, who's got what data that we could then go back to the legislature and make a recommendation on, is we sent a survey out to the heads of all criminal justice agencies. So all the law enforcement agencies, courts, probation, or I guess probation's probably under courts. So the county, attorneys and all of that. asking them to provide the survey link to their systems people, because we're trying to understand what RMS systems, CAD systems, there was several different kinds that we were trying to get at, what vendors folks are using, because we think ultimately it's going to be easier to get at a bridge to get at data through the vendor than asking each individual agency to do something. I'm going to send it. I'm going to send
to work with us. Need to have.
Okay, so we heard Molly twice there. So I'm going to resend out the email just so you kind of all aware, because I know you guys are maybe down more on the level of folks that would maybe get the survey or know the person who's going to get the survey. I'm going to send a follow-up email out to all of the heads this week for me directly. I think we had sent it out via Constant Contact the last time. Again, the more folks we have responding, the better a picture we're going to get of all of those different vendors that are out there, and how best to try and bite at that apple. So I just wanted to make you aware of that, so that in case any questions come your way about what does this mean, you're at least aware of what we're trying to do as step one. And I think somebody has their hand up, Mark.
I know. Katrina, you have a question.
Unmute. There you go.
Yes, just kind of a question and a comment. So do we know an effective date for the change in the fingerprint requirement regarding the when and where? And I only ask, we have started here in Pinell County holding quite a few of our DOC defendants. Their hearings are being done virtually using Polycom. And our public defender's office has been getting all the plea agreements and paperwork and sentencing documentation to the defendant at their facility, and then bringing it back and having it in court on the day of their hearing. And we've had a few hiccups with getting all the required paperwork needed. We started using DocuSign for our virtual initial appearance court, and we're wanting to begin using that with DOC to do their changes of pleas and their sentencings, and having this fingerprint bill changing to allow us to do it at DOC would be a huge benefit, at least for this portion of what we're trying to accomplish. So is there an effective date for when that requirement changes?
I can, let me spend a minute while the meeting goes on, and I'll put it into the chat box, Katrina.
Okay.
It's 90 days after the 30th, but I gotta go back and make sure that is, I don't remember if that's working days or just all days. So let me figure that out, and I'll put it in the chat.
We are wanting to pilot at least the plea agreement and sentencing portion using DocuSign with one of the DOC facilities here in Florence relatively soon, but we wanted to wait until the fingerprint portion was all worked out. Thank you.
Okay. Molly, did you have anything else?
I think she dropped off again.
Okay.
I don't think she did, Tony.
No, I'm back here. My internet. Yeah, sorry, my internet cut out for a minute, but no, Tony, I think that was it. Were there any questions from anybody?
We had one on the implementation date that Andy was going to feed.
So it's 9/29 is the effective date. I'll put it in the chat.
Okay. Thank you very much. Okay. Any other questions from anyone? All right, we will move on to our accomplishments portion. We did want to really quickly go over some things that we are doing well, which involves everyone. A lot of what we claim we're doing well in terms of NICS is a lot of hard work by all the agencies in the state that are working on DPS and their courts, especially working on some of these projects. But first thing I wanted to do is, Mark, if I can, you gave me permission to present, right?
Yes.
Okay. Let me do this. This one right here. Okay. Real quickly, wanted to show folks that as of last year, the new wait, mirroring. Don't share your entire screen. Okay. The new Arizona NICS improvement plan is on the ACJC website, and I've called it up from the ACJC website here. So it's there for us. It's pretty comprehensive. We've changed up the format thanks to Molly and Andy and the folks at ACJC who worked really hard on making this thing look like the original, but with some added emphasis on certain sections. So it really does lay our progress out, and all I have to say is it was a lot of folks contributed to this, got this in shape, and it's a really good document for us for funders out there from the department in terms of we have a plan, we have a strategy, we have performance measures, we have action steps to our goals and strategic plans. So this is a really robust document that is good for another 5 years. And then we'll be looking to update this again, hopefully with much more accomplishments in hand. But so we have that piece. I do want to show us one of is our mental health adjudications. There we go. I am sharing a screen here in terms of our mental health categories. One thing I wanted to show you here as I zoom in, I gotta practice being which screen that I'm clicking on here. But here's what we have in our mental health repository in NICS and what is at the AOC here. Did you see our categories? Mark, is that big enough for everyone to see?
It's not. Yeah, I think everybody should be able to see that they're at a computer. Yes, they should be fine.
Okay. So as of 2020, we have over 47,000 records in NICS in our mental health, in the NICS indices on mental health adjudications. AOC has been really good in terms of providing us a breakdown of where those mental health records come from in terms of breaking down by statute. I know that the numbers may not add up because if you're looking to add those up, because they float in and out of over time. So we do have a pretty robust and good mental health system. I am pretty sure, and I know Michelle's on the phone. I think our last question was, I think it's Pima County. Michelle, if we were collecting Pima County data, if all our mental health data is coming in from all our counties.
Tony, I don't think Michelle's on the call, but we are collecting Pima County data.
Okay. All right. So that's where we are with mental health. Now, in terms of, you can see our numbers there. In terms of one thing we wanted to show here was our denials based on, let me move this over, on what we have in the record system here. And as you can see, we have in the past year, in 2020, we did jump up considerably with mental health denials based on our records. Kind of a large incremental jump from where we were before. Got that over there. So, we went from, a high of an average of about 200 over past 4 or 5 years up to over 400 denials based on a mental health adjudication. So that was pretty significant. But I do want to point out that is, if you look at the bottom below totals, is the total number of background checks that were done for the state of Arizona, according to the NICS records or NICS reports. And so you can see that we almost doubled the amount of NICS checks in 2020 from previous years, from the 2 previous years. So that increase in mental health is consistent with the almost doubling. We almost doubled the mental health denials, but we also had almost a doubling of NICS background checks in that year. But that's a good thing that we're catching those. The other piece that we have in terms of, as we see here, domestic violence with AZ Point, we'll go back to how many records in the I can find it. Here's where we are. With AZ Point, again, we're almost at 1,000 misdemeanor convictions in domestic violence. Protective orders stayed. They jumped a little bit, but not as much as we had in 2018 when we began the project with and started implementing some more practices as we were going through the order protection AZ Point process. So we're expecting in 2021 to possibly see, we're going to watch that number to see if that increases or not based on what the impact of COVID had in 2020. So everything else remained consistent, jumped up consistent with the number of background checks that we had in Arizona. And so we just wanted to go through those numbers in terms of how well we're doing with mental health and how well we're doing with I wanted to find their AZ Point numbers. There we go. And I will enlarge that.
Hey, Tony, this is Andy. While you're looking, any thoughts on why the big jump in 2020?
Well, it's consistent with across the nation, there were, record numbers of firearm purchases in the United States. And so we had, we had a big, so ours was consistent with what, the election, thanks Amber, the election, COVID, people at home. We had an inordinate amount of gun purchases in 2020. The interesting piece with that in terms of domestic violence, and there's a bunch of new studies that have come out linked conclusively through peer review and through metadata analysis. And I have a number of studies that have just come out in the past month where at the peak of COVID, access to firearms, there was a direct link to direct access to firearms and domestic violence, injuries and deaths at the peak of COVID. So in that spring to summer time period, we had some pretty good data on weapons availability and how that impacted domestic violence. But the major reason was an election, and COVID created this frenzy of buying of weapons. And the good thing is our numbers, our background check numbers, we kind of followed the nation in terms of over time, about 0.6%, I think, in terms of denial rates for guns. And over the last year, with this buying of weapons that occurred, the nation kind of jumped up to 0.8%, and Arizona remained consistent with that number in terms of our denials. So that was that's a good thing. The bad thing is that, we're 10th in the nation in terms of gun violence. Arizona's in a very precarious, bad position in terms of gun availability and the amount of gun violence that we have. There's also a new study that came out from the GAO in terms of costs of gun violence, and Arizona is ranked. The cost for one person injured that hits our healthcare system impacts us in terms of folks that are injured because of a gun-related incident. Most likely will not be covered by any type of insurance, so their costs are borne by the state. And per incident, it's well above $40,000 per person that it's costing Arizona for every gun injury in the state. And we're up there in terms of one of the higher amounts that it's costing us in terms of cost to the state in terms of gun violence, how that impacts states in terms of health in our healthcare system. So
you had a question about the OP data. Someone wanted you to go back. Can you scroll back up to the OP stats just for a second?
Okay. Yeah. That's where we are, right? Those were the numbers. Mark, you can talk a little bit more. Well, we were going to do that in terms of data later in the morning.
Okay. Will do.
So the bottom line with AZ Point is time will tell the impacts. We know anecdotally from judges in terms of COVID, how it helped the courts. Access was was extremely easy for petitioners out there, victims of domestic violence. Our numbers, I would say, somewhat remain consistent with prior years, which to me indicates a capacity issue rather than, are we doing more with the system? I think Mark will talk later to, the system has provided us incredible improvements at our first look at it. So I wanted to talk about that a little bit. Was there any other questions? Yeah, Brandy said theirs doubled.
Yeah, they said the numbers more than doubled from a servicing agency standpoint. And we'll talk about that and what we're seeing from the data when we go through AZ Point as far as the numbers doubling. What I can say right now, the last count we got was that there are approximately 4,000 to 5,000 less orders of protection sought during the 2020 year compared to in previous years. So maybe an area numbers increase, but overall from the system, there is no correlation that the entire order of protection process and more orders were processed. So we'll talk about that later on in the agenda as we go through the AZ Point data.
What I have put up, and Mark talked about this a few minutes ago about the gap information. And there's the numbers in terms of, achieving success with gaps, with GAP. And with Department of Corrections and DPS, they get the big credit for solving this issue about making this work and getting us to this number. How 2075 impacts this, we may be okay because in talking to Jennifer Abbott's from DOC, and I don't know if Jennifer's on our call. She doesn't appear to be, but DOC made based on this, they kind of closed the door, which may help mitigate 2075 because DOC now will not. Someone shows up without a fingerprint, they won't accept him. So they've kind of shut the door for people coming in and actually getting into the system without a print. Well, if you transport there and they don't have the print, or they show up at the door, they're being sent back to the agency that created the to the court, essentially. So ADC is forcing folks back to the system to get properly fingerprinted. But I think everyone is so aware of this now that it may, hopefully they don't have folks showing up at the door with no fingerprints that they have to turn away.
Tony, the ones we have to be concerned about are the ones who get probation.
Yeah, and let's talk about that a little bit, Mark, because that's the nuance that's the problem. Go ahead.
So the concern is the ones that get probation, because in those, if they don't have fingerprints, then DPS is not going to be able to complete that criminal history on the conviction that they may have, that they have within the court. And so the concern is that you still could be sentenced to a crime, get probation, and DPS may not still have all the criminal history within ACCH. And then even if they do, if they don't have the fingerprint on that disposition document or the FDR, it will be hard for them to go in and recreate that criminal history. So we still have a blind spot in the way this 2075 was implemented. The way we will be able to tell is that if our open dispositions increase from where they are today, and they start to go back down to the 60s and whatever, where we have incomplete criminal history, that could be a telltale sign. And so, like I said, this is something we're just going to have to watch, and hopefully DPS will keep us informed if they start to see a lot of cases that don't have fingerprints and so forth, or the courts start to see they have a lot of cases that they can't send to DPS because DPS doesn't have a disposition on that case or whatnot. So this is going to be one of those things that we're going to have to put a bell or an alarm system on to continue to check back in to see how we're doing. Because you're right, ADC has closed the door in a sense, but now it's the ones out there that's on probation now that we don't know what the actual paperwork is looking like.
Okay. Does anyone have any input or comments on that? I don't know if we have probation on this call or in this meeting.
We have Bert.
Go ahead. Unmute yourself, Bert. Bert, are you able to hear us? If you can unmute and.
All right, we'll let him figure out his system.
Okay. I see you, Bert. Let me see. You seem to be unmuted. If you can.
Check your microphone, Bert. Make sure you're on the right mic in your computer. All right, Tony, let's move on.
Okay, so, and Bert, chime in if you can figure it out. We will stop where we are and listen to what you have to say. Okay, so now we want to talk about what's in progress out there. And I turn it over. Before I turn it over, let me start with the one that I can give progress on for you, and that's juvenile felony delinquent reporting. I have talked to Joe Kelroy. I think I've said this the last 5 meetings that in the next couple months they will go live. With COVID and other things going on at AOC, I sympathize with Joe, but he again is hoping that sometime before the end of this year, the juvenile division will go live with reporting felony juvenile delinquent records to the NICS indices, much like we do with mental health adjudications. So we will see that in our numbers, in our category 1 numbers. They'll jump up in terms of what's in the indices when that gets perfected. So that's where we are with that. But Mark, I will turn it over to your staff to do the rest. So
there was a question that came in, Tony, from Hathaway.
If you want to unmute, you can certainly ask your question.
The question is, do you know if that will include past convictions or just from day forward?
Yes, my understanding will be from day forward.
Okay.
We'll double check and we'll make sure that we get that message out with everyone to make sure that that's correct. Okay, Mark, can you have your staff do progress on our projects that we are that ACJC is champion?
All right. So with AZ Point, it is quote unquote, I would say 98% fully deployed within the platform for the agencies. The last improvement that we made was that we added the ability for the servicing agencies to manage their own users. We deployed that around July 15th. So now when an agency needs to add a user or take out a user, they have the ability to do that. We also went into a rewrite of the declaration of service due to some DPS requirements for improvements. And so we're currently working on revising the declaration of service to meet the standards that are required. Once we do that, the next thing we would want to do with AZ Point is to be able to allow the servicing agency to make corrections to the DOS if need be for a certain period of time. But right now, the AZ Point system is working the way we thought it should. We have a couple of more DPS audit things to resolve. One of them deals with validation that is still being worked on. And the other one is, like I said, the DOS. Once we complete those two requirements, I believe we will be in good standing with all the requirements being met for us in this AZ Point platform. What I can tell you is that the system, like I said before, is working like it was designed to work. And we're constantly making improvements based on feedback from the field. So with that, I will take any questions about AZ Point before I go into the data that's not really data related. If you have any other questions about usage, access, or anything like that.
Okay, Heather has a question. This may have been asked before. Why does one have to search by one county at a time in AZ Point rather than just one search that covers the entire state?
And that has to do with all right, here's a little techiness. All right, so that has to do the way the service is written. If you try to pull that entire database, it will crash because there's a lot of data out there. And so trying to just run random searches and whatnot could cause the system to slow down and cause it to time out. So basically, most of the time when a servicing agency encounter a person or a victim that has an order of protection, if they don't know much, but they know the order of protection was in a certain county, will allow you to search that county by that name and find that individual. So we tried to make it intuitive as possible, but we just can't handle you being able to search the entire database. And that's just the way it was built.
Okay. Shelley commented that to get around that, they gave everyone admin access.
Well, it depends on what you say admin. All you would have had to do was, yes, you would have had to give that person admin access. That would be correct. Because other than that, you would need to know the plaintiff's first name, last name, and the county in which the order was issued. If that's something you think we ought to look into, we can look into that. And basically what you're saying is on the general search criteria, you would like to have more flexibility in how you search.
Yes, please.
Okay, got it.
TPD, that would be great.
Bert, you got two speakers open somewhere about the feedback.
Shut off the sound for one, Bert.
Can you hear me?
We can hear you now.
Yes, we can hear you now. Yes.
I was just going to say that we work with the prison to anything coming from our jail to make sure that they get them. We also work with the courts and probation. But as Mark said, if they don't go to get their fingerprints and they're going to get probation, those definitely slip through the cracks. We do have a program that we do every day with the 3 courts, and they send us all the people that are coming there, and they're not supposed to be heard in those courts until they have a PCN. And then we tell them which ones don't have that particular charge on their rap sheet, and they send them to us to be done before they go back to court for their hearing. But of course, things still slip through the cracks, but it's a lot better than it was.
Okay. Thanks.
Okay. Thanks, Bert. Okay.
All right. So that was a follow-up to our question that when we were talking about the House Bill 2075 in the gap. Is there any other questions on AZ Point? So based on the feedback, you would like for me to look at providing a little bit better search feature for the general search. So you don't have to have everybody, quote unquote, as an admin.
Looks like you're developing a consensus on that.
All right. ADRS XML interface implementation. We are just about at the end of the ADRS implementation process as it relates to the county attorneys. I believe we have 11 agencies that have the same platform, which is PBK, and our last agency that we're implementing right now is Greenlee County. Our only holdup now is DPS still hasn't stood up their test environment for us to be able to start testing the ADRS XML with these county attorneys' offices. But the ones that we had online, which was the largest one, Maricopa County, we've seen a tremendous increase in completed dispositions when they were turned on. So the only thing we're waiting on right now is, like I said, to start back implementing the county attorneys into the ADRS environment is for the test platform to come online. And I think it's more like online consistently because they bring it up and they take it down. If somebody from DPS could speak to that, that would be great. But that was my last update. Do we have anybody from DPS? Tony?
Yes, Melanie and Amber, they're on the phone. So,
Can one of you all speak to that? Am I correct?
Mark, I don't know where IT is with doing their programming. As you know, we just went live with our new ACCH a couple months ago, and we're still working through all of that process. Is there anything in particular you want me to follow up with IT about?
Yeah, I guess the only thing we're waiting on is the test database when it's going to be stood up so we can start testing the ADRS XML to bring it back online, to start bringing the agencies back online.
Yeah, I asked them a couple weeks ago about that for you, and they had not done that yet. So let me follow up with them while we're on the call real quick, and I'll get back to you.
Yeah, if they can just give us a date, maybe we can then preliminary start scheduling the agencies. That would probably help us a little bit. But sure. We know how it is when you go to a new platform, trust me. So we can imagine.
It's working better than expected, but it's a challenge.
yeah, and Mark, and to support what you talked about, we've, our last run of our table run with dispositions, rest with a case disposition. over time. Overall in the state, we've improved quite dramatically in terms of numbers. And the only thing we can attest this to was the ADRS project.
Right, when we put in Maricopa. Yeah.
Right.
We have we still have Navajo. So I mean, if we can get these other sites on board, our numbers will start to look really, really great.
Right. Well, I think they're looking great now, so it's definitely showing some massive improvement.
All right. The other thing is the mobile fingerprinting. Right now we have 2 FID devices in all the superior courts, or they have them. Some of them have not turned them on. At least I know about 3 superior courts that are waiting on this phase 2 feature, which is basically the new mob device will let the court know if the person has been fingerprinted for the charge in which they're currently before the court on. And Mojave County is going to be our pilot for that, but Mojave County recently moved into a new courthouse. And not only did they move into a new courthouse, the vendor has improved their mobs. So we're waiting on new mobs, which is the 2 FID device. So then they can start to pilot the new feature. So when someone goes before the court and they put their fingerprints on the 2 FID, it will let the court know that person has been fingerprinted for the burglary charge that they're currently before the judge, and not for a past, let's say, robbery charge. Right now, what the 2 FID devices do, they just let you know that person has fingerprints within DPS. It doesn't let you know that they've been fingerprinted for the presenting charge that they're before the judge. So hopefully, with this new feature, and we can test this out in Mojave County, hopefully then we can deploy this to all the other superior courts, and then we will be able to more accurately have fingerprints for the presenting charges, which in return will allow us to make sure we have complete criminal history.
Okay.
So that's where we're at on the 2 FID. We had a meeting like a couple of weeks ago, and we're still waiting on the devices so we can deploy them. Any questions on the 2 FID? All right. One more thing about the 2 FID. I think this is a worthwhile project, and I'm still interested in putting some of these FID devices in municipal courts. But due to the pandemic, that is kind of slowed, and people are trying to get caught up on their projects. But that is still something that I'm interested in, is putting these devices in some of our municipal courts to see the value added in helping with complete criminal history. So we'll see how that plays out over these next few months, and go from there. I seen one that said send one to Glendale. Well, it's a little bit more complicated than that, but if we're going to start up an expansion of this, we'll look into it.
What are you doing? We don't need anymore.
We're ready.
Of course, we'll be here next month.
The next thing on the list is e-warrants. So our e-warrant project is back up and running. Our statewide e-warrant project, now that all the new warrant forms have been deployed to the JWI interface. It is showing good. Before we had to go through the warrant revision, it showed great promise. And now we know it works, and it's continued to show promise in regards to saving time of processing warrants and providing information to all parties involved. The next phase of this project is to look at how to expand this. We do not have a team together right now to do the expansion of this to other police departments and other courts, but that is some value that's been talked about at the commission level of how we could do this and what type of resources this would take to do. So we're gonna similar to the mobile fingerprinting project. We're going to look at these projects after our October session and then see what is viable and how we can do this with the resources we have, because I'm quite sure everyone is limited on resources at this point in time. And we'll go from there. Are there any questions on e-warrants or mobile fingerprinting? I know I went through both of those. All right, seeing no questions on either one of those, we'll go to turn it over to Tony for unresolved issues and prioritization.
The next session is meant to be an open discussion so that we can have some get some direction going into our October meeting. These are issues that we have addressed and talked about a number of times that have just we have not been able to resolve for various reasons. And that's understandable. Some things we may never be able to cross the bridge on these things. But we do want to, as we move into October, we do want to talk about these. We do want to say, okay, this is worthy of walking in or keeping in the mix and re-energizing or re-examining it, or this is something we'll never get done. And so low-hanging fruit, let's just move on from there and concentrate our resources in our time and discussions on something that is productive. So, but there are a number of issues that have come up that continue to surface from the stakeholders that we do need to have a little bit of discussion about. The first one that I put on here is the active warrants to NICS, active warrants to NCIC. And we keep running into this issue of, are we entering misdemeanors, non-extraditable offenses into NCIC, and whether there's been a policy established. And I'd like to bring in and put on the spot Patrick Priel from Scottsdale, because they've done a really great job of getting these misdemeanor warrants, non-extraditable warrants into NCIC, and have had some really good benefits from it. And we're so what do we do with some of these things? So I wanted to start the conversation off with active warrants and see if we can get some conversation on, where are we at with this?
Tony, thank you. Hello, everyone. As most of you know, Scottsdale, since July of 2013, had entered all of our warrants into NCIC. These included the so-called rule warrants, the 3-1D and 2612C, and we've entered them all in. And we've had over 100 people denied firearms through NICS because of them having warrants. First, it was because just having the warrant, and then in 2017, when the rule came in and changed that they needed to, that wasn't the criteria for fugitive of justice, they needed other criteria. We worked with the FBI to find ways, either by sending the FBI NICS a copy of the citation they signed, acknowledging that if they didn't show up, there'd be a warrant issued for their arrest, or sending NICS the disposition, that if they didn't comply with certain things, there'd be a warrant issued for their arrest. Thus, they knew that they would have a warrant if they didn't do certain things. So the FBI would use that as criteria for fugitive of justice and deny them a firearm. So we've been through a couple DPS audits and an FBI audit, and everything was fine. And the reason I brought this up is that in March, then I heard from another agency, SSO, that they had gotten an email from DPS saying that rule warrants are not to be entered into NCIC, that they're civil warrants. Now, I'd never heard of this before, and I asked our court, and our court said, we don't issue civil warrants. They're not. They're criminal misdemeanor warrants, but that the prosecutor just would drop the charge. So I contacted DPS, and DPS said, no, they're civil, and that in 2017, DPS and the courts, I don't know what court, made an agreement that they're not to be entered into NCIC because of the way they're coded and that they consider them civil. So I contacted my legal advisor and put it up in him and say, what should we do? And at first he came back and said, they're not civil warrants, they're criminal, continue to do what you're doing. And then 3 days later, after he talked to the DPS legal advisor, I got an email said, stop entering them into NCIC. Just because of the same thing, that there was some kind of agreement between DPS and the courts. Now, I bring this up to ACJC because of all the meetings that I've been to, I never knew of any agreement between DPS and the courts to say that we can't enter rule warrants into NCIC, when the FBI has told me in the audits and praised us for entering those warrants in. We've literally stopped hundreds of people from getting guns. So by following the direction of our legal advisor, right now, as of since March, we have 5 warrants that we enter. 3 of the warrants we enter into NCIC. 2 of them, the rule warrants, the 2612C and the 3-1D, we only enter into ACIC per our legal advisor's direction. But I bring this up because I don't understand why we can't enter them all in, because as the courts that I've talked to, they're not civil warrants. They're criminal. So I don't understand where that's coming from. And I guess in my point is that I think if entering these warrants in has, for officer safety wise, if we give information to any agency or any officer in different states that this person may have a warrant, they're going to approach things differently, even if they're not extraditable. So that's where I brought up to Tony and that, because I think we need to find, are we entering them in? Are we not entering them in? Or can we enter them in? And so that's where we are right now. So as I said, for Scottsdale, the rule warrants, per our direction, we are not entering into NCIC, but I want to do what we were doing before because the FBI wants us to.
Yeah, if anyone can enlighten us, because this is discussion after Patrick brought this up, we discussed this with Mark, and we're kind of, if there's some policy out there, we certainly would like to get that out. So, Patrick Scott.
Yeah, how you doing? Going way back for when the rule warrants were first initiated, because they didn't have a criminal charge, they were put into the APHIS civil menu because there's no charge for the rule warrant itself, but it's attached to a criminal case. And that means that the person is non-compliant in some way with the orders of the court. And if it's a 3.1D, the case is unadjudicated with an open disposition. And the 2612 is post-adjudication, non-compliant with the court order for whatever the sentence is. So, you can kind of see how somebody would think that it's a civil warrant, but it's not really, because it's in a criminal case. And we were having this discussion with AOC. Actually, it's ongoing right now. They had coded the failure to appear warrant to automatically go to NICS, to NCIC, with a no extradition code. So our police department was saying, we don't want that. We want it actually just to be Arizona only. And can you get them to open up that extradition code so that you can enter it into the Arizona side rather than into the federal side? So that's an ongoing conversation at this moment.
Okay.
But I think, to Patrick's point, the question is it an officer safety issue or is it a discretionary? If this is going to promote officer safety, then I think as a policy for the state, you want to put those in and you want to do it with the no extradition. But that's above my pay grade and I won't be here anyway.
Yeah. So Melanie, if you can explain the technicalities behind in the U code that you put in the chat, that would help.
So this is Amber.
Okay.
The difference is that the system allows you to enter an M or an F for felony or misdemeanor. There is no U designation to launch to the FBI, the federal level. So I think that's where the confusion is coming in, is if it's got a U designation, how do you enter it? And if you're changing it to an F to launch it nationally or an M to not launch it nationally, you just change the order in some way. And when DPS says that we've worked with the courts, we mean AOC. So Patrick Scott is correct. This is a continuing conversation of how to get these out there, because we would like all warrants to be national, but we have to follow the proper process of,
Correct.
Is it an M, an F, or a U? And if it's a U, then we have been advised that it's not appropriate to launch it nationally.
But what is a warrant that is a U? A 2612C and a 3-1D are misdemeanor warrants.
Yes, but if
So
a lot of
why-
the agencies are putting it as a U, as an undesignated, that it's not supposed to be sent out there.
Okay, and that was my thing, is that we were always using it as an M and putting it in as an M. And we had no problem until, as I said, I found out from another agency that they got an email saying, because they were doing the same thing, got an email saying that you shouldn't do that, that 3-1D and 2612C are civil warrants and that you have to use the U. And I was like, what are you talking about? And then when I talked to DPS, they said, yes, we want everyone to stay on the same page and that those warrants are civil and you have to use the U. And so we were using the M before March and we had no problem. So I'm sorry, go ahead.
No, you're fine. So I'm not extremely versed in warrants because that's never been something I've had to do. So let me check and see if that U designation was something that AOC came up with, or if it's something that DPS and FBI came up with. Let me do a little bit of research and figure out how that came about and who made the rule as to how a rule warrant should be designated. Because DPS tries not to dictate that because you guys are the courts. But that had to come from somebody besides DPS. Patrick, I see you've unmuted at this point.
Yeah, I mean, that was part of the conversation, when the rule warrants came to be. And I'd have to go back and look through my stuff and see if I have anything to add any clarity to it. But it is attached to a misdemeanor offense, I think is what Patrick's point is. It's not there as a standalone instrument.
And one thing that my legal advisor had mentioned to me is that after speaking with the DPS legal advisor, that DPS, they said, was in lockstep with the courts, and the way the courts have coded the warrants makes them ineligible for NCIC. So I guess that's the question for the courts. Has the courts coded them as a U? Or are they still, as I said, when I talked to the different courts that I talked to, they said they don't issue like civil but they only issue misdemeanor. So to me, I guess I'm looking for ways to see if we can have, conformity of that we're able to enter these warrants into NCIC.
And I think part of the problem here is while the court issues a warrant, the court doesn't enter a warrant.
Right.
So when we say a U versus an M, they may have no clue. But like I said, we've worked with AOC on this, so we'll go ahead and take a step back from this and look at it again to see if we can bring the whole picture together. Because as Patrick Scott said, this has been going on for years, and it's way beyond my time. So let me do a little research and see if we can figure out who created the U designation, and if it's an order by the courts, and if we're allowed to enter it as an M, or if it has to be changed to an M. There's more people that need to be involved in this conversation besides me.
Right.
Thank you.
Yeah, just got a message from Julie, who's from Julie Alquist at MCSO, that says they used you for failure to pay child support arrest warrants and only enter rule warrants as M and F. If that provides any clarity to this topic.
Well, what it does is it kind of shows that we're completely inconsistent. But that, Amber, that will help. I mean, I think what everybody's looking for is clarity on this entry piece. I heard you when you said, DPS doesn't dictate who, what you can enter or what you don't enter in the NCIC, but we have to be in conformity with NCIC rules. And I think it's a matter of, okay, so what, it seems like what specific warrants, are used and what is M and F's, I mean, I think that's the piece. And if everybody has a different definition, then one agency, Scottsdale, sounds like you're okay to do it as long as you don't enter the U into the system.
And that's the thing, is that we never entered the U until I was told to enter the U by DPS.
Yeah.
And I know that at the beginning of this process, just from being in so many meetings regarding different types of warrants, that there was a huge group at AOC that created the form because they wanted it to become standardized, because people were booking the rule warrants as FTAs, which then created a whole new problem. Right. So there's a lot that goes into the history of this. And like I said, DPS, we follow the NCIC rules and all those different rules, and we push them out there to everybody to comply. But in the end, it's up to you to comply. We can't make you. So we'll get some clarity and figure out how this all came about and what the proper process is. And hopefully AOC will then shove it out statewide rather than holding it to their chest and not letting every court know.
Would that be something that the AOC has to establish the policy, or is that?
We would have to work as a group to make sure that the policy is in line with the FBI's national standard,
right?
Which we thought we had already done, but apparently there's a lot of confusion statewide. So we'll readdress it.
Very good.
Thank you,
Amber. Any other comments or questions on that? Kathy.
Yeah, I just wanted to make a quick comment on the question about policy. I don't know that it's so much a policy issue as it is something that we're going to have to look at in terms of how we actually developed our AJAX system. So I think it's an automation technical thing. We can find out from them whether they've changed something in the warrant issuance. And I don't know if it has anything to do with the e-warrants project, which we are working on and have just recently launched that as well. So I think we need to pull all those things together and kind of look at, are we consistent with the e-warrant as well as with the manual warrant process in the way that those cases are coded. But I don't think it's a policy that we have to take it up to Dave or anything like that, Tony. I just wanted to let you know that it's probably just something we need to reach back and get clarification with the automation team.
Okay, because I don't remember, I was on most of those e-warrant things, and I don't recall that type of change taking place, but you're right, in the automation process, it may have. Judge Finn, you have a...
Yeah, so when the rule warrants first started, what happened was the police departments did not know how to enter the information, so they came up with these different ways, like using the U. And maybe there's a change in terms of policy with Supreme Court and DPS. but they were able to be entered, just like Patrick Priel said, as a misdemeanor criminal warrant. It may have come up again with the e-warrants, but this goes back to when we first started doing rule warrants, and the police departments didn't know how to enter them.
Yeah, thanks, Melanie, for your comment. You know, that's a concern, Mark. Does the system requirements for e-warrants, you know, inadvertently cause a change in practice?
I spoke with the lead automation person on the E1 project, and she said she wasn't aware of any changes that would have impacted the entry of the warrant. And so I did bring this up when it was brought to our attention because I thought E1 may have been a contributing factor to the change. But from their standpoint, they don't believe it did anything to that extent. So maybe it's like Amber said, we need to get a group of people together on the automation side and maybe walk through what the issue totally is in relationship to entering those type of warrants through the Ajax platform. And the reason I say that is because Scottsdale is not on Ajax. So they may not be impacted by something that the Ajax courts are impacted by. So Amber's right. We probably need to put a fact gathering group together just to talk through the process and see if we really need to make any changes at all, or if it's just a simple thing of an agreement that this is how we want to have our state deal with misdemeanor warrants or rule warrants of that sort. And it could be as simple as that, depending on how large the issue is.
Right. Katrina.
If I'm remembering correctly, way back when we started doing rule warrants along with Patrick and everybody else, it had to do with how the officers booked them into custody and what print type that they were using. And they mirrored the rule warrants after the civil, I think it's a 6.1 warrant for like jurors who failed to appear in court, or a civil arrest warrant. And I think that's why it's not extraditable, if I'm remembering correctly. So when you guys meet with the stakeholders group regarding that, do ask about the print type, because I want to say that that's what generated the U to be put on those warrants.
And that is correct. If you arrest on a rule warrant, you're supposed to do a print type 04 because there are no new charges or the prosecutor will refuse to file charges.
Okay.
And before we were doing rule warrants, they were booking them under either like the fail to pay 28,810 or a failure to appear charges, creating inaccurate criminal histories because there is no charge for those rule warrants, but they didn't know any other way to book them in. So I believe it all stems from the print type when they're booked into custody on those warrants.
This is Melanie. Katrina is correct. And the reason why we created the U, the undesignated entry or message key for rule warrants was because the police departments didn't know how to enter them. So we created the U, so it'd be Arizona specific only. And again, it would be a print type 04, not a print type 01.
So this limitation, and let me add, and Melanie and folks can, is this limitation based on where we were years ago in terms of how our booking system operated, and not necessarily something that it can be changed because we have a different system or a different approach to it? Or are we still wedded to this way we've done business before in terms of booking? That seems like the root of all issues, right?
Tony, I don't know if that's the case. We don't know. I mean, we can't say it's wedded to the booking or if it's something else. At this point in time, we don't know. That could be a factor. But at this point in time, I think it's fair to say we don't know.
Well, undesignated warrants were really created in 2015 because of the booking of FTAs, the issue that was created for that. So I don't think it's because it's something that we've always done. It's only been a few years since we started doing undesignated warrants.
For the rule warrant.
For the rule warrants or for child support arrest warrants.
And Melanie, just a quick question. Since Arizona created the undesignation, is that why the rule warrants are not extraditable? Because only Arizona recognizes the U?
Yes, you're correct.
So I guess my question is, and maybe we still have to wait to get together for a final answer, but instead of using the U, can we use the M so that they can go into NCIC? Because when I asked that, I was told no. I was told that they're civil warrants. And I still don't understand that because other people have told me they're not civil. So I guess I'm trying to find the answer out so I can tell our legal advisor and we can feel justified to go back to doing what we were doing before, is entering the rule warrants in NCIC so that they're nationwide. They stop people from getting guns that shouldn't get it, and for officer safety. Can we just, instead of using the U, use the M and do what we've done before?
I'm not making a decision on that if you were told something else, because like I said in the chat, I was not included in that conversation between your legal and my legal. But I do have Mary Sue Galindo here in my office, and she can explain part of the undesignated warrants and why the rule warrants are supposed to go under that.
So the rule warrants, the reason the U designation was created for that is because a rule warrant is not a misdemeanor or a felony. So by putting a misdemeanor or felony classification on a rule warrant, that is inaccurate for criminal history purposes. The U designation for a rule warrant is in fact just a U. It's not a misdemeanor or felony. The underlying charges that are affiliated with that rule warrant are misdemeanor and felony. But the whole idea behind a rule warrant was it's Arizona only. They wanted to get the subject of record in for pre or post adjudication issues without having to create an additional 01 print on their record. If they had already been previously printed on those charges, why would they get printed on them again? And why would they print them on an FTA instead of it being a rule warrant as a U as an 04 print type?
Okay, and then, but see, from my court, I was told that they are misdemeanor warrants.
The underlying charges are, but the rule itself is not.
And unless I misunderstood, I was told that it is a misdemeanor. They just won't charge on it, but it's still a misdemeanor criminal offense, failure to appear or failure to comply. So it is a misdemeanor. They just won't charge on it.
No, Patrick, this is Kathy. I don't think that's correct at all. I think it is still a civil warrant. It's just a means to pick up an individual. It's not intended to even indicate that there was an allegation of a fail to appear. So I think it really is the fact that it's a civil rule. And therefore, I can't imagine that other states are going to be able to recognize our civil rule as something that they would pick somebody up and even extradite off.
Okay, well, I guess when we have entered these in, we've gotten hit confirmations from different states. And of course, we put there and say it's valid, but we will only extradite Maricopa County. Thank you very much. And that's it. And there's been no problems with that. And as I said, the FBI, when I went through the audit with them, they were so happy that we were putting these warrants in. And so they accepted them as well as misdemeanor criminal warrants, knowing that they're rule warrants. Because I explained the whole situation with them, and I explained the 5 different types of warrants we put in. And I guess that's the thing, is that if these warrants are helping officer safety, for example, someone in Florida, an officer pulls someone over who has Arizona plate or whatever. That person knows that he has a warrant. He thinks that officer is pulling him over for that. He's more apt to do something dumb to try to get away, but that officer was just on a regular traffic stop. To me, I'd want to give, I don't care if it's a rule warrant or not, that officer that information so that he can approach it differently, especially today with the amount of, things that are going against police or what Tony had said earlier about the amount of, shootings and gun violence that is going up. If we can stop someone from getting a gun, why does it matter if it's a rule warrant or not?
Hey, Patrick.
Well, this is
Go ahead, Melanie.
so Julie Alquist made a message, and she's correct. Arizona has a message key. Arizona puts all of their warrants into what's called the SWQ message key. Therefore, any state in the United States can query our warrants. We are our in-state warrants that are not in NCIC. It's the SWQ message key. So there's always a way. Not every state contributes to this, but Arizona does. So all of our in-state warrants, even those undesignated warrants, can be queried by any state.
And I understand that, but will they do that? Wouldn't it be easier?
That's up to the individual person running I can come up with a million different what if scenarios, but the thing is that there's a reason why we have the undesignated warrant. Misdemeanor and felonies are only accepted by the FBI or NCIC.
Well, I think that, Patrick, we're not going to, there's going to be a lot of policy things and issues, technical issues with systems and things like that. I think the recommendation of putting a group together is what we need to do to kind of ferret through all these different disparate type of scenarios and issues that go with it. So that there is a comprehensive policy that goes with this. Julie's question Julie's point is good. You can enter it in the ACIC, and then Patrick, your counter that now it's dependent upon the officer making the stop, making a specific inquiry into Arizona's records, is somewhat problematic. But where this will be resolved at, I think, maybe in the middle somewhere.
Julie has her hand up. Go ahead, Julie.
Yeah.
Can you hear me okay?
Yes.
So an issue that MCSO has run into in the past is that even though we clearly identify our extradition limitation in the entry, we still get those 10-minute hit confirmations from out-of-state agencies, even though we clearly say like a adjacent state only. And then we'll get a call from, Florida. Are you sure you don't want to extradite? We've chosen to not put we have 16,000 criminal misdemeanor warrants, and we don't put them in NCIC for that reason. I have 50,000 total, and it's really hard to answer those hit confirmations when law enforcement agencies don't look real closely at the extradition limitation that we put in our entry. So we, pretty comfortable knowing that NICS can still look at every single one of our warrant entries because the state of Arizona provides them that key or provides them that tool that even might fail to pay child supports. Really, NICS can look at those as well.
Yeah. So you're saying is that the gun denial issue is taken care of through this key. The officer safety issue is questionable whether it does that, but how many that affects is another thing.
Well, there's another side to it when a police officer is on the side of the road and sees a warrant pop up. Is there a different level of and it might be a insufficient personal flotation device warrants, not having enough life jackets on board at the lake. Does someone in New York need to look at that? Does someone in Montana need to see that warrant right on the side of the road on a traffic stop? I don't know.
Good point.
I don't think so. And I don't want them doing a 10-minute hit confirmation to my staff to see if we're going to extradite on that warrant.
Right. Kathy Claridge?
I'm good.
Okay.
I was just going to make a suggestion that if either before or after you get this group together, I could write up a legal issues question for the folks at the AOC to weigh in on the legality of putting rule warrants into NCIC and whether or not there's a legal concern with that, or whether or not we identify that there's a process issue.
Yeah. Well, I think with Julie's, bringing up the ACIC and that NICS can see that.
Yes.
I think we just need to get that out, and it may cover majority of the issues for us, type of thing. So clarification to all the agencies out there, will go a long way, instead of how Patrick, kind of learned, okay, no, you can't do this, when maybe Ajax related, some remote kind of reason why he got that answer from a different part of the state. So,
thank you, everyone.
Okay. Next thing we wanted to discuss was the dual warrant purge. Patrick Scott brought this unique piece up. Patrick, are you on?
Yeah, and it's the locate thing that Julie was just talking about. Even though you're not going to do the extradition past, Maricopa County, people still do the locates. And if you get a couple of locates, that warrant's going to automatically purge. And so the court's going to have an active warrant, but there's not going to be anything in the system.
Okay.
And currently we don't get a notice that it's purged. We only find it when we're doing validations. And we did a complete run. DPS gave us a complete file of all of our warrants. And I think we wound up with like 47 of them that had purged because of locates that we were not aware of, that we could have, reissued a warrant on those cases.
Okay. Julie?
So yeah, we discovered that earlier this year when DPS implemented the new message key, that there was reports that holder of record agencies weren't receiving anymore. And I know that DPS is trying to re-implement those reports. And one of the reports is warrants with locates, or warrants that have been purged due to two locates. So we're in the same boat right now, in that warrants have been purged automatically from ACIC, and we're not aware of it because of some reporting issues with the new message, with the new switch.
Okay.
So agencies need to not place a locate if extradition isn't been approved, or if our entry clearly says we won't extradite.
And if I can just bring up too, is Patrick Scott had said about getting the two locates, and maybe because I had to go away a little bit, but maybe I missed it. But since last year, now one locate, if you locate a warrant 5 days later, it's automatically purged out of ACIC. Per the upgrade of last year, they did exactly, or they follow now what the NCIC does. Because if your warrants are in NCIC and it's located 5 days later, it's automatically taken out. Well, now ACIC does that as well. So you don't need to have two locates on a warrant. It will purge it 5 days later. And that's why, and if someone sends a locate and they have local charges, per the manual, the agency is supposed to put a detainer on it, and that holds it in the system.
Okay. Any comments to that? Anybody want to add anything? Melanie, you can correct me wrong. It sounds like DPS is aware of the issue and trying to recapture that that piece. Is that correct?
I'm sorry, I stepped out to use the restroom, so I didn't hear Patrick's question.
Yeah, it was on this dual warrant purge, and Julie brought this up that you guys, with the new switch key, it created this where they're not getting a report on the purge. And
so Melanie,
yeah,
Melanie, with the monthly validation list, previous to the message switch change, we received a report every month of warrant entries that had to locate, or warrant entries that were purged out. Whether, and it could be a locate, it could be a warrant purged because of the child is a juvenile and they reached emancipation age, and that's just a report we're not getting anymore. And it I mean, you guys know about it.
We're well aware of that. And when it first happened, we reported it to our IT. So I don't have an update on that. We're still working through post go live issues. Again, we went live on April 18th. We are still having daily post go live calls. I'm not saying that there's a lot of stuff wrong with the system, but we have to get the core issues worked out. But that is a topic of discussion, and it is on our list of things to work out. So
perfect.
I don't have a timeline for you on that.
That's perfect that you're aware of it and you're working on it, and that's great. So that answers that. Okay. All right. We'll move through them. The next thing I had on our list was the CCW permit rep back. We ran that in legislation, correct, Mark?
Say that again?
The wrap back for the CCW. Did that make it to legislation, but didn't?
No, it did not. It did not make it out of legislation. The only wrap back bill that was passed during the last legislative session that allowed DPS to do something pertaining similar to wrap back for a certain segment.
Okay.
Maybe Andy or Molly can weigh in on that bill that was passed last session, not this session, but the previous session.
I'd have to go back and look at it again, Mark. It's been a while since I remember looking at it.
Yeah, same, Mark. I don't have it handy, so I can go and look for it though.
But maybe DPS can update on it, where they're at with their wrap back thing. Melanie, are you aware of where you guys are at with that?
Melanie, you're muted if you're trying to talk.
I don't know if she's aware of the progress on that. That's not our bureau.
Oh, that's not? Okay.
No. Same, it's all TSD, but it's a different section.
Okay.
Okay. We'll ask on that. I put up on the screen for you, and this is from the FBI report, the concealed weapons permits, and it's based on, I don't know how many actual concealed weapons permits are issued, but from the background checks for this concealed weapons, FBI NICS does put a report out by year and by month on these background checks. Something I just wanted to point out was, it is rising, and through 6 months of this year for CCW permits for Arizona, we're almost, it looks like it's going to double for permits, even though the actual purchase of weapons is falling off in 2001 back to previous levels. The CCW permit background checks for Arizona are going up dramatically. And since Arizona is an open carry or concealed carry state, where no permit is needed, this appears to be about reciprocity with other states.
Hey, Tony, it's Melanie. It is. It totally has to do with reciprocity with other states because we are an open carry state. I'm sorry, I was having technical issues. But as far as the Rat Back program, and including CCW, we're kind of doing this in a phased-in approach. We are not moving to Rat Back until we are 100% in production with our new ABIS, the Arizona Biometrics Identification System upgrade, which is sometime in November. So we anticipate moving a couple of other sections here at DPS forward with Rat Back and in that first quarter of next calendar year, but CCW will not be until after that.
Okay. Till the system's perfected. That's good.
Yep.
That's good news. That's good.
But they will be moving to Rat Back.
That is very good news. Type of thing. But that's the reciprocity. As other states clamp down on concealed carry, I guess we'll see more of that. I bet you most of them are from California. So, but anyhow,
I know all the sex offenders that we're getting are mostly from California because we had about a 1,200 or 1,400 increase in number of sex offender registries as well. So,
wow, that's very interesting.
And Tony, also, I don't know if you know this or not, there is a huge group of other states that allow citizens of their own state to carry a weapon if they have an Arizona CCW license. So, for example, if you live in Michigan, you can have an Arizona license and you're complying with the Michigan law.
Right.
So they come here to get those from us.
Wow. That's pretty. The sex offender thing is kind of a scary proposition. So, okay. All right. We got that. Conditions of release. The big project that I thought would be the game changer is
the conditions of release project is on hold for the moment. It is still a worthy project. We just got to look at how we deploy this thing, and we got to go out and talk to some courts and law enforcement agencies and the AOC to look at how we can do this on a phased approach instead of just trying to get everybody on board at one time and go from there. So it's not quote unquote dead at the moment, but we got to basically start back from the beginning to get people on board and to get us some pilot courts to participate. And some law enforcement agencies were fine. They didn't have an issue with it. It was really more so the courts. And then after that, we then can start to show its value similar to the other initiative that we have done.
very good. Very good. Felony convictions to NICS. I think that we're doing this, and I see the numbers. The question is, are all counties reporting felony convictions to NICS?
No.
Okay.
13 Ajax courts are reporting felony convictions to NICS, or let's just say the Ajax courts. But Pima and Maricopa County is not reporting felony convictions to NICS. And maybe there's just a conversation we probably need to have. We haven't had it in a while, so maybe that's something we can look at since we have the feed going through DPS at the moment. It's just a court-to-court conversation, but like I said, everybody got a lot of projects that they're trying to get caught up on due to the pandemic, and so I don't know how much of a priority they will possibly give that, depending on how many dispositions they have on their caseload that don't have fingerprints.
Well, yeah, I get that, but now with 2075, the felony convictions to NICS becomes a little bit more important.
Well, like I said before, with 2075, we don't know the impact, so we can't say yes or no to that. Is it possible? I don't know, but we currently do not know, even before 2075 takes effect, we currently do not know how many dispositions that Maricopa has that has no fingerprints. We don't know that right now today. Or Pima. So we don't know the impact. And so, like I said, that would be a conversation that would have to be had to ascertain that information. Yes, Donna Hall had a question. We're talking about convictions with no PCN. That is correct. We're talking about convictions with no PCN, meaning they hadn't been fingerprinted.
Meaning they may not be visible if it's their only charge.
That's true too.
To anyone, and so there's no prohibition in place. Okay.
That is correct.
All right, so that kind of ties in with the probation issue. Okay, there's a lot of pieces in there that kind of all tie together. So.
Donna Hall say, okay, in terms of no prints, we send a report to DPS every couple months of cases with no PCN. Yeah, but I think DPS, Amber, I think this would be Amber, what do you do with that report? I think you've always sent that report, but I don't think DPS is really able to put that into criminal history because it doesn't have any prints.
Sorry, trying to find the right screen. We just do basic research. So she provides us a PDF and we go through it and we reach out to the agencies and notify them, hey, Phoenix PD, the court has this information for this subject. Please provide arrest information, including fingerprints. I'll tell you, maybe 1 out of 200, we get a response from the agency actually providing us the arrest information. If it's a new arrest, we're likely to at least have them say we don't have it, but when our officer goes to court for the next hearing, he'll try to address it. We typically don't get a follow-up after that, but it's really, really, really rare. I got one today where Coconino from another county told me that they had booking information so that I could go to the sheriff's office since it wasn't the PD who fingerprinted him, but it's a hit and miss, but Donna does provide it to us and we do try to work on them and try to get responses.
Okay. Julie?
So Donna also shares it with MCSO and we attempt to go back and create those gap fillers as well. There's times that another agency and local law enforcement booked into our jail. They told us they brought their PCN with us and that tells our system don't do an 01, but we still, our goal is to do an 04 on every person that walks in our door no matter what. So there's a lot of times that we're able to resurrect that 04 and then turn it into an 01. So Donna shares that list with me as well, and then we work on it the same way.
Okay. All right, so the next thing we have is the final disposition report, the FDR. Have we sunset it yet? Is it gone?
Not in our lifetime.
They just had me modify it last week.
It's not gone. Oh my gosh.
It's not going to happen, Tony. It's a wish.
So I know that last time we talked, I think it was a couple of months ago, I had told everybody that if they want to get rid of their FDRs and they're using ADRS, that I would be willing to do an audit with them to make sure that they're using ADRS properly and providing the information to us. Okay. I have had one agency say that they want to do that. In August of 2020, I sent them their audit, and I have never heard back from them. So there's not many agencies that are as eager as they say that they are.
Yeah, I agree.
So you're saying that they won't walk the walk, they'll talk the talk, but they won't walk it. Okay. So I put up on the screen here, whoops, a little too big. Our last statistics on disposition charges by submission type. The only question I have is, we have paper and ADRS web and ADRS XML. Can those numbers be, can we be double counting disposition reports in there?
No, but you can be double counting charges. So,
yeah, I think that's what I meant was.
So what happens is a paper dispo comes into my unit today, and as you see, last year we received 159,000. My staff goes in and enters, modifies the record in the way that the dispo says. So for example, if the person is charged by the officer of standard DUI 281381A1, right, and he then gets to court or to prosecution and they up the charge because it's his second offense or third offense, and they have marked amended, DPS will amend charge 1 to be the new statute, 281383A1, whatever it may be. We'll amend the charge, and that's a one-for-one beautiful total. ADRS Web is the same way. They open the record, they see he was charged with standard DUI, I'm going to amend it to the higher DUI, great. But if they're doing it through ADRS XML, depending on the programming of their computer system, it is an exact match. They will send in a message from their system saying that they want a standard DUI. If it does not see a standard DUI, then it will bring back no results. And so when they enter the standard DUI, it will then add a new charge. So you see that a lot when they do amend a charge. So it starts as standard, but they're looking for the extreme DUI. Our system doesn't have an extreme DUI yet because nobody's updated our system. So then you'll wind up with 2 charges when there really should be 1. And so one's left hanging without a disposition. That makes sense?
Yeah, it does. It does. I'm just kind of wondering, the effectiveness, well, how we could measure, how we could draw any effective conclusion from the measures that we have based on your explanation.
I think the only way to do it would be in the extract that we give you twice a year is for you guys to look at the extract and say, okay, so this next to on the far right column of the rap sheet, it'll say added in new charge added through ADRS. For you guys to look at that and say, okay, he started out with standard DUI and it does not say it was added by ADRS, but then he's got a charge directly below it that's a new ADRS charge of the same type of crime. And for you guys to get those numbers that way. Because the system is going to break it down for you if it came from ADRS as a new charge or not.
Okay. All right. Candace, you are taking notes on that, right? That'll be important how we ask next time.
And I can show her where to find it on a rap sheet. I know her extract is different, but then she'll at least know the wording that she's looking for. And I know that when my staff comes across it, so if they come across DUI where we're saying that he's got a charge added that's the same, we'll do the modifications to fix that, to take out the extra charge and to amend the original charge to the new statute that it's been changed to. But like we've said before, we can't be proactive with 11 million charges. We're reactive. So it's when somebody has prompted us to look at the record for some reason, right, that's when we're finding this.
Is for DPS, is this a labor intensive activity that with use of ADRS would be able to I'm just saying, is it taking up a lot of staff time cleaning these things up?
Absolutely. 2 years ago, I had 18,000 corrections in my unit. We're down to 3,500 at this point, but those are the ones that just have been identified to us. It definitely takes up a lot of our time. I would say one correction can take between 5 minutes and an hour and a half, depending on the severity and how much research goes into it.
Got it. Thank you for that. Okay, next piece, it's something we talked about, the misdemeanor conviction and domestic violence statute ambiguity, I think, designation. Kathy, I don't know if it was Kathy, someone came up with a form to capture misdemeanor domestic violence. Wendy Million did out of Tucson, I think, that had all the elements in it that kind of made it easy to look at. But so the question is there any need or is there any value in trying to modify the statute a little bit so it clearly identifies what's a misdemeanor conviction domestic violence prohibitor as opposed to not in statute?
Are you talking about what type of relationship for federal prohibition?
I don't think it was the relationships. It was the in statute. I had trying to pull it up here, but I think it was the nuances in the paragraphs in terms of what represented a prohibiting misdemeanor domestic violence conviction. I'm probably not explaining that right.
The only thing I know about is relationship of victims.
Yeah, I think we're good with that. I think it was the type of violence or the type of activity or action that is charged in statute. Some of it meets the definition to make a federal prohibited possessor, and there are some pieces that are not prohibiting.
So you're talking about like harassment versus physical assault situations, right? Okay. Yeah, I don't know much about how the FBI reads those. And I know that a lot of times it's applied wrong. For example, not with domestic violence, but with the minor. Right. We see a lot of minor in consumption, and they put that it was a minor victim. Well, if it's the minor that's drinking, they're their own victim. That kind of convolutes it there. But we do see like domestic violence added on FTAs. The act of not showing up to court was not a domestic violence issue, but the original arrest was a domestic violence arrest.
Okay.
That kind of stuff.
All right. Well, we'll discuss that a little bit more in terms of down the line, maybe if we need to actually, if it's important enough to bring back up. Amber, do you know if you're getting are there a significant number of calls from NICS trying to clarify that with you that you know of?
I can't say how many request that. We don't keep track of it. What we do is when we get a NICS request, we kind of ignore their wording as far as what they want, because we know that we're not going to get a response 9 times out of 10 anyway from the agency. So what we do is if I get a request that says, please provide me information on case number, blah, 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 date of arrest, blah, 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 I just blast that out statewide to the arresting agency, prosecutor, and court that may have been involved. And then I provide all of the documentation to the FBI, because they may want 4 or 5 parts. They might want to know the victim, the use of force, if there was drugs involved, the quantity and the type. So we just give it all to them, and they can ingest what they want, and then their system purges it 24 hours after the case is closed anyway. But then I have it again if the subject gets tries to buy a new gun a year from now. Then I don't have to send that information back out to the agencies again. I can just provide it back to the FBI a second time.
Sounds good. Very good. Okay. All right. And hopefully people are taking breaks as needed along the way. Mark, we get the AZ Point data.
All righty. As you all recall, back in 2017, 2016, the premise of the AZ Point system was to do three things. One, to provide greater access for the plaintiff to have access to the courts. Two, to make the process more effective. And three, to make the process more efficient. Back then, what the data was that it was basically taking an average of 23 days to get an order from issuance into NCIC. So the way that broke down was that it was taking 13 days from the time in which the order was issued until the order was served. And then it was taking approximately 10 days from the time the order was served for it to hit NCIC. Also during that time period, only 50% of the orders were being served. So the court was issuing about 40,000+ orders a year. Only 50% were being served during that time frame. So finally, we have some preliminary data from AZ Point to give us an idea of how the system is working. So first, let me say that everyone knows starting January 1st when we launched, we had hiccups, stating it mildly, in the system. But we got all the information cleared up for the most part. We still have some issues with Maricopa, but we're not missing quote unquote cases. And so we're able to get everything synced back up. And so what the data I'm about to talk about now is data from basically January 1st, 2020, all the way through our last extract we got was like June 3rd of 2021. And I'm gonna break this down into two segments. First segment is from January 1st to December 31st of 2020, and then January 1st of 2021 through June 3rd of 2021. So in January 2020 through December 2020, there were approximately 32,000 orders of protection issued. All right. Of those orders issued, 20,000 was served and 10,646 was not served. That was a percentage service rate of 66.2% of the orders were served. So right now, as I told everyone when we implemented this platform, it takes about 3 years for any system to get fully integrated into a large bureaucracy like government in a sense. This is a statewide impact. So we've already seen the increase in that process. Now, the good thing about that, and it's going to sound bad, was that the average number of days from the order being issued until it was entered into NCIC during 2020 was 14 days. That still is a 9-day improvement. Why? Because the way the system works today is that orders that are served are entered in NCIC twice a day. They're entered in the morning and the last run is in the evening. So we went from 23 days to basically 14 days from issuance to entry into NCIC. Now that was during the year in which we had tons of hiccups. The platform didn't come up the way it was supposed to, and us steady building the program the way it should be. By 2021, so far, by the June 3rd of 2021, we had 13,000 orders issued. Of those 13,000, 8,000 were served, and basically a service rate of 62.7%. Now, the average number of days from the time it was served until it hit NCIC went down to basically 6 basically 7 days. So it cut it in half. So 7 days is still way better than the 23 days that it was taken before. So based on this, the system is starting to do what we anticipated, that by us changing our statute and improving our processes, we were striving for. And to give you a little bit more data on that, 23% of all orders are served the same day that the order is issued in 2020. But within 2 days, 46% of the orders are served. And within 7 days, 71% of the orders were served in 2020. And once again, this was with this being a new platform for all agencies involved to learn and adapt to. So in 2021, so far, on the first day of service, the number gets better. 24% of the orders are being served on the very first day, the same day that the order is issued. Within 2 days, 50% of all orders are being served. And within 7 days, 77%, or basically 77% of all orders are being served within 7 days. So once again, it is showing that the new process and the new system is working. And it kind of shows how valuable the system was during the pandemic. Because at the time in which we rolled this out, we were going through our hiccups, but the courts and law enforcement needed a way to have limited contact with the general public. And by us being able to move the order of protection totally electronically, provided that space and allowed or assisted in keeping everyone safe from having that type of contact with multiple people from the public the way it used to be. So what we're hoping for is that once this year is complete, right now, as I stated before, all of the features that we had said will be available in the system have now been deployed. We're still working on 2 features that's required, which is the validation and the rewrite of the DOS, which should not impact the service component of the orders or the issuance of the orders, just more so coming in compliance with the audit that DPS did on the system. And then hopefully by the end of this year, we will continue to see the process improve. And another reason we're hoping it's going to improve is that we're slowly integrating everybody and they're understanding how to get things in the system the same day. So after this second year, the training will be more focused on when you serve it, enter it from your car, instead of taking it back to dispatch, maybe have them enter it. We built a system so the servicing entities can enter it in the field, and we were to utilize that more. I think our times will continuously improve, and we will see the true value of this platform being deployed within the state. I would say this is one of the biggest game changers as it related to government and implementing a new process. And it's one of the best that's in the country. Because even though most people, even the state we pilot this out for Indiana, they don't have the ability to allow the victim to be able to complete this order anywhere. Most of them have to go to a victim service agency or something like that. We have totally given the plaintiff access to the courts and completing information. So when they show up to court, the only thing they need really is their name or their confirmation number, and the process can kick off. So with that, we do have some other stuff we're looking at. We're looking at, for example, how long, hopefully we'll get this information, how long does it take for after an order is served to when it's entered into AZ Point? So I can serve an order today, but some people may not enter it until tomorrow. So we're still trying to get data analysis and formulate a good report on the system, how it's working, and some of the processes we could hopefully enhance in looking at where our gaps or our blind spots may be within this new platform. Like I said, we don't have all the data yet. It's not all ready and cleaned up to where we can publish anything, but we are working towards that. And hopefully by this time towards the end of the year, at the first of next year, we'll have a much better report to show you the utility of this platform. And with that, I will take any questions anyone may have on the AZ Point data and what we're seeing. I guess the question is, for you all that are out there that may have the opportunity to work with AZ Point, have you all seen an improvement?
Yes.
I heard a yes from Patrick and a yes from Kelly. So as usual, as you all know, our phone numbers and emails are always open. If you have problems or issues, because it's a system. You're always going to run into some bugs or hiccups. Just keep letting us know and we'll keep moving the ball forward and improving this program.
The other neat thing is we continue to get, Mark Stapp, Shayla is responding to a number. We get the out of state. We get issues that are coming up in different counties with out of state service or something to that effect. So it gives us an opportunity to kind of engage and see how the system works. Not only in Arizona, but how the service part is actually working, especially with these orders that are out of state being issued to Sheriff's Department and Sheriff's Department facilitating service, especially in states like California that have that a lot of the counties, San Bernardino, Riverside, that border Arizona, try to make victims pay, try to make victims actually show up at their court to get their orders registered, and in some other states. So we've gotten to deal with some of those issues, which have been really enlightening and help out along the way and kind of clear a path for the next one that comes up. So it's helped us see a lot of different issues in different areas of the state also. So it's been good.
Hey, Tony and Mark, before you move on.
Yes, sir.
I just wanted to kind of echo our chairperson, Sheila Polk, who's the Yavapai County attorney at our meeting we just had last week at the Law Enforcement Summit, made the comment that, she's been in office for 15 years, I think, or somewhere along those lines. And she said that in her opinion, this project, this new system has been the biggest change, the biggest improvement to the criminal justice system in Arizona since she's been in office. So kudos to the team at the courts and the DPS. And Mark, your team, again, I get bumps in the road. I get it, bringing a new system online, but where we are today compared to where we were, 4 years ago, and the way that process was working has been a huge improvement. So, great work all. And I continue to look to see, the numbers and stuff when they come in and what we can do to promote the work that started with this task force. Thank you.
Thanks, Andy.
Yeah, and just to add to that, last year, Mark and the team got to present at the National Coalition of Domestic Violence Conference on this. And so, again, being recognized outside the state by organizations of doing things. Mark, something came up in the thing about did you talk about integration into records management systems?
No, we're looking at how to do that. And right now, just to be honest, a lot of agencies are going through new RMS systems. And so, as with anything, they're afraid to take a new plunge into something else, which includes bringing in their vendor to do whatever else. So we're looking at another possible way to look at that, maybe leveraging JWI or something like that to get this thing integrated so agencies doesn't have to go to two platforms. That was the whole point about a system was that you can work right out of your RMS system or your CAD system. But we're still trying to figure out what's the best way to integrate this seamlessly so you're not into two systems. So that is the challenge right now. And it's just something we're going to have to walk through as this thing progresses and see where we're at. I mean, we would love to, but you got to have a willing participant to do it. And right now, we have no willing participants that's raising their hand and say yes. Once again, they got projects they're trying to get caught back up on.
Very good. And there's a lot of in the chat room, there's a lot of information being shared. So that's good.
Marcus Polchagoya.
Yes, sir.
One of the items that came up recently within the last 30 days were the injunctions against harassment that reside in the system. And the scenario tangentially touches upon it. And it is regarding 2 points. Within Arizona, the statute provides that service agencies, such as the sheriff's offices, may charge a fee for the service of injunctions against harassment or workplace harassment. I understand that the governor recently signed a document for federal funds, which attested to the federal government that the state does not charge for service of those particular documents. That is not consistent with the statutory scheme, and we have been trying to tackle this internally of what to do when we have customers who arrive at our public counter requesting service be conducted on these particular type of orders. And so what I'm pointing at is perhaps there needs to be a statutory fix so that it's clear to the sheriff's offices or any other agencies that charge fees for service of injunctions to understand what is permissible and what is not permissible. We would ask that this be a wider discussion. Maybe this is the appropriate time, maybe it's not, but any insight or any information that you might have now about potential statutory revisions is helpful.
All right, so Molly, can you look into what Paul is referring to? But I can tell you, based on what I think you're referring to, is the VAWA Reauthorization Act that governors have to sign off on that say they don't charge for, or they don't charge a fee for, like, orders of protection. So I would think that our orders of protection is the document that is, some people use injunctions, some people use orders of protection. Our orders of protection are free. They don't require service. And also our injunctions that has a victim component like sexual assault is also free for service. So I don't know if it's a statute change that is needed to be required. I think the issue is the terminology that the government allows that has an umbrella. So for protection orders as it relates to the Violence Against Women Act, we do not charge for orders of protection, which puts us in compliance. Also on certain types of injunctions, one that has a sexual component to it and the other one that has a domestic component to it, we do not charge for service of those injunctions. So I don't think there is any clarification that's needed. If an injunction meets one of those two criteria, it is free for service. If it doesn't meet one of those two criteria, then you can charge for the service.
Mark, I'm going to disagree with you.
Yeah, Mark, this is Andy. I think we need to look into it a little bit more. So Paul, thanks for bringing it up. That's the first I had heard of it, but I wasn't obviously paying as close attention as you are. So let us do a little research and let us look at it a little more closely and see what we need to do. But we can certainly, we can facilitate a conversation with the governor's office if needs be.
The point is not to be put off by the fact that, a fee is not being charged. I want to be clear about what we should do as a matter of procedure and policy on our part. I do not want a situation where, particularly for my agency, that we would endanger any funds that would be given to the state of Arizona by complying with the state statute.
Correct. Yeah, no, that if there's something that's in conflict, we need to get some
Paul, can you send us that document?
Yes.
Thanks, Paul. I appreciate it.
Okay, Mark. That's it with AZ Point?
I believe that is it with AZ Point. If no one have any questions.
Shelley, thank you for Mesa PD's brochure. I've got it now. That was fast. Shayla's good. She can spread the wealth out pretty well. Okay, this is any new ideas, any new issues, an opportunity for anyone to speak up on anything that they want to talk about. Hearing nothing. What we'll do is the next meeting is in October. I think we have it set for October 20th, correct, Mark?
I don't know. I think it may be like October 12th. I'm not 100% sure.
All right. Candace sent something out to hold for us, but the October meeting, our plan is to we've gotten to a point where we need to wipe the slate clean, take a fresh approach to the NICS task force as we did when we walked in the door in January of 2012, and begin looking for new ideas. The other thing that we do is what we have, what we've discussed today, those things that have unresolved, to kind of prioritize them, put them in perspective so that we can put the task force back on track in terms of strategic planning and action steps towards resolving issues that we can resolve, realistically resolve.
I'll just say what Tony's trying to say nicely. It's time to put the task force back to work.
Yep, exactly. So the next meeting, we plan to do more of a facilitated discussion meeting. Not so much an agenda, but an idea session where we break up in groups, where we discuss, where we vote, we prioritize, we talk about problems, we talk about solutions, and we talk about barriers to those solutions, and come up with a focus, get us back to work on priorities and on projects that we can successfully attain and then sustain over a period of time for our next period of 4 or 5 years in our plan. So that's what we plan to do. We'll be working on getting out an agenda, a format, this format will have rules, but if you're like Pat McGrath, who was with us originally when we started, and Patrick Scott, who was originally with us when we started, much like our very first meeting, where we all got very noisy and threw out ideas against the wall to see what would stick and what we would work on. And pretty much all those ideas have what we've been working on for the past 10 years. So we're moving forward, and that's what the format's going to be. So it's going to be a fun meeting, and hopefully it will be all of us together face-to-face meeting again, like we in the post-COVID world. So